Hi, I'm Jim Richmond with the Department of Business and Professional Regulation. I serve as the Executive Director for the Florida Building Commission and have been working with the Commission now for about 16 years. Here to speak about the Florida Building Code for about 10 to 15 minutes. That should be well within safe tolerances for non-hazardous viewing, but if you do begin to feel lightheaded, resort to YouTube and seek out your favorite viral video until that feeling passes before continuing with this video. The Florida Building Code could really be referred to as a best or a worst practices document. It is essentially a set of regulations that define the worst construction that anyone can complete in the state of Florida. Works hand in hand with the Florida Fire Prevention Code adopted by the Division of State Fire Marshal at the Department of Financial Services. Defining what the code isn't often helps kind of get an idea of what the scope of the code is. The Florida Building Code is not a building maintenance code. It does not have continuing operation to keep up the code or keep up the condition of the building in the status that it was when it receives a certificate of occupancy. Essentially, once that certificate is given by a building department, the code doesn't apply again for its intended purpose at any rate until a new permit is pulled and additional construction activity is planned for that building. There are many jurisdictions that adopt a building maintenance code that do specify the amount to which you need to keep up the walkways and the structure, but the building code does not provide that guidance or direction. The building code also does not define who can perform what function when it comes to construction activity. That's done by various licensing statutes and the different licensing boards, also at the Department of Business and Professional Regulation in large part, but not the Florida Building Commission itself, nor the Florida Building Code. Lastly, the code doesn't define where something can be built. That's done in Florida by land development regulations, zoning regulations, and other laws for which you may find informational topics on the same website that this one was found. The code is a document that's generally based in this state on a set of model codes, primarily those adopted by the International Code Council. And those model codes are generally referred to as the International Building Code, and the other subjects are covered. Notable exceptions to that, though, are that the electrical requirements that we enforce in the state of Florida are strictly from the National Electrical Code, which is maintained by the National Fire Prevention Association. It's a different model code organization that runs on a different cycle, which sometimes complicates matters in terms of which version of the code is regulating what project. The accessibility requirements contained in the code are more directly based on standards for accessible design adopted by the federal U.S. Department of Justice. And then included within the Florida Building Code are various construction regulations historically adopted by different state agencies relating to what's called in the code special occupancies. And those are hospitals, other healthcare facilities, public schools, swimming pools, mausoleums, columbarium, and other things along those lines, and are mostly found in Chapter 4 of the Building Code within their own specific subjects, but those are specifically adopted for application in Florida. The Building Code and these foundation codes are subject to modification by the Florida Building Commission. There are several different means by which the code is modified. It is updated every 3 years to track the model code organization's updates of their documentation. And every time the code is updated, it's subject to a statutorily defined process for developing the code, number one, and number two, ultimately, the Chapter 120 rule adoption process, which is an overlay of the code development process contained in Part 4 of Chapter 553, Florida statutes. When going through the triennial update process, you start from the foundation codes, the model codes, and certain Florida-specific amendments are rolled forward, particularly those relating to special occupancies that I referred to before, those relating to Miami-Dade and Broward counties treated as the high-velocity hurricane zone in the Florida Building Code. Those are rolled forward into future additions to the code without further action. But all other Florida amendments from triennial or from update to update are sunsetted, subject to being resubmitted for future consideration as well. So essentially, these proposals can be accepted from anyone in the interested public through the Building Commission's website, which is floridabuilding.org, also referred to as the Building Code Information System. Those modifications are reviewed by a committee of the Commission, referred to as a Technical Advisory Committee, and have to receive a 75% favorable vote of the Commission to actually be moved forward into the Florida Building Code. This process in full takes about 18 to 24 months to complete, and as referred to briefly, can include multiple opportunities for public input. And these occur both at public hearings and through the information system, where written comments can be submitted on the proposed modifications that would in turn be reviewed by a committee and or the Commission through the process. Outside of this triennial update cycle, there is an additional amendment process regularly used by the Commission and loosely referred to as the glitch amendment process. And that's primarily used to address changes in statute, other state agency rules that affect the building code requirements. Standards updates, as I referred to before, the National Electrical Code is typically updated a year to a year and a half after the international codes are updated. So there's often an interim change to the building code to adopt the most current electrical standards. And other standards are similar. And then there are other limited circumstances identified in 553. And for this glitch amendment process, only the Chapter 120 rule adoption process applies. So it can be accomplished really within 6 to 8 months because you don't have the code development process of Chapter 553 overlaying with the rule adoption process. Statute still as well authorizes annual amendments to the code. Those have not been utilized in recent memory, primarily because the regularity with which the code is amended between triennial updates really has provided a lot of criticism to the Commission and difficulty in adhering to the code and enforcing the code. One important point to remember is that the code version that's in effect at the time a complete building permit application is filed is the one that will govern the entire lifespan of the project for that permit at any rate. This isn't a circumstance where the permit has to be granted or issued in order to vest the person with regard to the code version that's in effect. The building code as well is subject to limited local amendments, which are supposed to be uploaded by the local government to the building code information system at www.floridabuilding.org. There is some slight difference between the restrictiveness of administrative amendments, which really govern the business practices of the local building department, versus the technical amendments to the code, which are the technical construction requirements. Technical construction requirements are extremely restrictive as to being amended at the local level because the entire theory behind the building code was more uniform enforcement throughout the state. And by having a uniform basis from which to enforce the code, that was felt to really further that. But we did have to account and do have to continually account for the fact that we have a vast variety of resources in the different building departments going from the multi-million-dollar operation in Miami-Dade County to the two-man building departments out in the Panhandle. Well, and where local technical amendments are adopted, They are sunset as well every time the building code is updated every 3 years. So if a local building department amends the code to require different things within their jurisdiction, that amendment would drop out upon the effective date of the next triennial update of the Florida statewide code, unless it's been readopted by the local government. The code itself, as well, is effective upon adoption by the Commission under the Chapter 120 rule adoption process, regardless of whether or not local jurisdictions adopt a local ordinance to apply the code. There are several local jurisdictions that we hear about continually that tend to update their ordinances to specifically adopt the building code, but that's wholly unnecessary. It's applied by state statute. Moving on really to the processes of the Building Commission in relation to an adopted code, there are several that provide benefit to the regulated public. The one thing the Commission is authorized to do that's regularly accessed are accessibility waivers. Florida's accessibility code includes at least 3 or 4 requirements that are not contained in the federal ADA or its related rules, and are in fact actually more stringent than are required by federal law. The one most regularly encountered is the requirement for vertical accessibility. In Florida, every change in elevation greater than ½ an inch has to have some accommodation for people with mobility impairments, right? People in wheelchairs or utilizing walkers. And those accommodations are typically accomplished by ramps and elevators. With a lot of the existing construction in the state of Florida, and one that we see all the time is South Beach and Miami-Dade County, where these buildings were built prior to the accessibility requirements, integrating these requirements into existing buildings is extremely difficult, costly, and sometimes technically impossible. This process, the waiver process generated by the Commission, is to address those circumstances and to afford a regular means to waive the requirements to the extent necessary to make the law reasonably applied. There is one circumstance in which a waiver is absolutely mandated, and that is where the cost of providing the accessibility it exceeds 20% of the construction cost for the project. That's referred to as disproportionate cost, and in that circumstance, the Commission is required to grant a waiver. In all other cases of technical infeasibility or even economic hardship that don't rise to the level of disproportionate cost, that is discretionary with the Commission. They actually receive a recommendation from a group of 6 accessibility advocates. They're appointed to a group called the Accessibility Advisory Council and meet approximately 6 weeks before a Commission meeting and deliver their recommendation to the Commission. All materials for accessibility waivers, including the application and submittal of the fee associated with the waiver application, are incorporated on the Commission's website at www.floridabuilding.org. This is not the classic Chapter 120 waiver of a building code. This is a waiver process that actually predated that and falls along its own processes that are provided for in the Commission's rules as well. The next process that the Commission regularly engages in is an interpretatory process through declaratory statements. That is a classic administrative process and is provided for in section 12565 Florida statutes and 28-105 Florida Administrative Code. Declaratory statement by the Commission can pretty much detail how the code would apply to the particular set of circumstances identified in the petition prospectively. Now, the one interesting thing about the Commission's authority to grant declaratory statements is that in 553.775 sub 2, the statute provides that the code is required to be interpreted in a manner consistent with the Commission's declaratory statement. So it essentially establishes and recognizes the existence of declaratory statements as precedents, although that has created some level of discussion, at least in the appellate courts in other subjects involving declaratory statements. And that is an interesting particularity of the Commission that has not been explored by any appellate court. There are numerous limitations to declaratory statements, though, which really have rendered them of at least limited usefulness to the construction industry as a whole. Number one, they are required to be issued by the Commission itself at a duly noticed public meeting. The Commission's practice is as well to refer them to a committee in advance of that meeting, so there is a time period of upwards of 90 days between filing a petition for a declaratory statement and actually getting a result. That doesn't seem to dovetail well with construction industry's need for more immediate input. Additionally, these declaratory statements can only apply prospectively and can be only sought to apply to prospective conduct and cannot be sought to really govern the conduct of another. The context in which that regularly comes up is basically a contractor seeking to have a declaratory statement declare that a building official is wrong. And that's certainly not a process that we can utilize this for. The building official can ask what the correct answer is, but the contractor can't basically ask it can't ask the question in terms of the building official's action. There are, however, some processes that have been developed statutorily outside of Chapter 120 that do address those limitations. The first and most common are the non-binding interpretations. The Commission, the Florida legislature has created a section 553.775.3H of Florida statutes that basically has directed the Commission to establish this process and rule, and really under agreement with the Building Officials Association of Florida, affectionately known as BOAF, this has been implemented. Essentially, BOAF on their website has an electronic form, and it is as simple as question and answer. You basically submit a question, and within 30 days, you will get an answer from a group of building officials with some level of expertise with regard to the issues presented. It's much more timely, and it has been really well received in terms of governing the conduct of building departments, in that it's essentially a peer review and peer input. To the extent that that's not successful, however, there is a binding interpretation process that's been created in the last 10 years or so in 553.775.3C, and that is governed through the Commission and run through the Commission's website with an appropriate form. There is a complication because that form needs to be printed out and clocked in by a local building department for certain time constraints. It's as well a lot more complex because it really is an appellate mechanism for local opinions in this case, or local applications of the code. There is a trigger point based on review by a local board of adjustment and appeals if one exists. Additionally, to prohibit basically stonewalling these decisions. If a local board doesn't reach an opinion within a reasonable time, you can come straight to the Building Commission as well. I believe there have been all of about 2 people who have negotiated that entire process to conclusion since that process was created.